Thank you. Mr. Spiller, at the hearing in State Affairs on this legislation, there was no witness testimony from a lawyer that stated that House Bill 4 was constitutional, correct?
Could you repeat that question?
There was no witness testimony from a lawyer at the State Affairs hearing on House Bill 4 that stated that your bill was constitutional. Is that correct?
I can't recall. I did not invite any lawyers to come give their opinion, but I can't recall.
Well, I can tell you that there was no attorney who said it was constitutional. In fact, every practicing immigration attorney stated that House Bill 4 had likely had constitutional violations. But I want to discuss a certain provision of your legislation, the deportation sections starting on page 2, line 17. So it states that in subsection E, a peace officer may, in lieu of arrest, remove a person detained for a violation of this section, and then it goes through 3 different provisions, correct?
Yes.
So, and the peace officer would include DPS or county officers, local city police officers, even down to a school resource officer. Is that correct?
Yes, it's all law enforcement officers, as that term is defined under the, I believe, the Code of Criminal Procedure.
Okay, and that discretion of those peace officers to take this action of removal is entirely at the will of the peace officer, correct?
Yes, I assume that they would have discussions with other law enforcement officials. I can't imagine those decisions being made in a vacuum, but yes, they have that ultimate authority.
Okay, and your bill doesn't have any specific language or provisions regarding when the peace officers would need to take that action or make that choice of either arrest or removal, correct?
Correct. They would make that determination presumably after discussions with others, maybe prosecutors, maybe DPS, maybe other law enforcement authorities, to make a determination of what they do in this particular instance. And the good thing about this bill is that it gives law officers discretion and the ability to make choices, whether they seek to have one removed, whether they want to have them prosecuted, or whether they choose not to prosecute at all.
And I think you hit on a significant point, because you said that it would be generally after consultation with either prosecutors or other experts, right?
I would think so.
Because the determination that they're going to make about alienage on the first page, which is one of the elements of the offense, is a complex determination, right?
Well, I think it's a decision that's made on an individual one-on-one basis. You may have a situation where you have someone, a parent and a child. You could have some men that, I mean, certainly they need to check into it and see, look, are these folks that are here, if they have previous criminal histories, if they're documented terrorists, if they're on the FBI terror watch list, or whether they, and if you have a child, would the child and the parent certainly together be returned. So all those things, I think, would be made by law enforcement, and I trust them to make those decisions.
Right, so it wouldn't be an easy decision that they could maybe make on the spot, right?
Well, they could make it on the spot, or they could certainly go to some law enforcement facility. I don't think decisions have to be made on the side of the road if that's where they encounter them, or crossing a field if that's the instance. But I think certainly at some location they can make those determinations, yes.
But there's a lot of factors for them to determine whether a person is a quote-unquote alien under your statute, correct?
Correct, and I think law enforcement generally makes judgment calls in the field, or certainly after a stop or a detention in virtually any instance, and make a decision. Do we charge this person? Do we not? We take them into custody? Do we write them a ticket and with a promise to appear? There are any number of things that they may take into consideration.
Right, and so they may not make that decision right away. Let's say that you have a United States citizen who doesn't have proof that they are a citizen, like they don't have their passport with them, they don't have a copy of their birth certificate with them. What happens in that circumstance when you have an American citizen who an officer suspects may be violating this new sweeping state crime?
Okay, I don't know of a single instance where a U.S. citizen has been, even under federal law, under 8 U.S.C. 1227 or under 8 U.S.C. 1225, that has been removed from the state of Texas or this country.
But that wasn't my question. My
wrongfully.
question is, what happens if a United States citizen is stopped by an officer who suspects and they cannot prove that they are an American citizen? And an officer has to make a determination of whether this person that's stating they're a citizen is actually a citizen or not. What happens in that circumstance to a United States citizen?
Well, I'm just saying I doubt seriously that that's going to happen. People, if they're citizens, can usually say, look, this is my driver's license number, this is my date of birth, this is my name, this is where I live, this is where I go to school, this is where I work. I mean, I can't imagine, this bill is not directed toward deporting or removing U.S. citizens. I don't think that's the purpose of the bill at all.
And the problem is, while you cannot imagine it, this has happened before, where United States citizens that cannot prove their citizenship have been detained, and so you have violations, potential violations of United States Constitution that United States citizens can claim that, which I figured that's why you had those indemnification provisions to protect the counties, right? If something like that were to happen from all the lawsuits that can be filed in those circumstances?
I would say, first of all, under the federal statute, the federal government removes people that are here illegally on a regular basis. As a matter of fact, from 2016, 17, 18, and 19, the federal government averaged 328,000 removals a year.
But those weren't my
I don't know of a
questions.
single instance where any U.S. citizen was wrongfully removed from our country.
Well, I may remind you about Operation Wetback, where American citizens were deported by the thousands back to Mexico by the federal government. So this has happened, and it's an open sore and an open wound for people of my community, and which is why we're raising these concerns. But I do want to talk about another issue. What happens if Mexico does not accept the return of a non-Mexican migrant at the land port of entry?
Okay. And what I think is they're just like we have 50 states, Mexico has 32 states, 4 of those border Texas. And our governor has memorandums of understanding on border security where they have agreed to cooperate and fully cooperate with us in border security matters. And my understanding is that they will abide by that. They will comply with our requests, and that won't be an issue. If it is, then we'll deal with it accordingly. But we have every indication, based on the Governor Abbott's memorandum of understanding with each of those states, that they will cooperate with us.
I'm glad you brought up the MOUs, because that was raised at the hearing, and we researched and looked into this. And in fact, these MOUs with the Mexican states of Chihuahua, Nuevo León, Tamaulipas have no language accepting migrants from Texas. And in fact, were you aware that any such type of agreement would be required by the Mexican federal government? So they have laws. It cannot be negotiated, the state of Texas with these border states. It has to be any type of agreement where a country is going to take migrants has to be negotiated between the federal government and the federal government of each state of Mexico and the United States. So those MOUs, with all due respect, Representative, do not give the authority and would not be able to give the authority. So that's a big, big issue that we have to address about what's going to happen to these Mexican migrants or non-Mexican migrants that are not accepted by Mexico.
Okay, well, let me say this. I respectfully disagree. And under the 10th Amendment to the U.S. Constitution, Texas reserves and has certain rights to contract with and to work with the states of other governments. And I believe that Governor Abbott had full authority to contract and do a memorandum of understanding. I've read those agreements, and I frankly believe that it is done in the spirit of cooperation. They have pledged to assist us in border security matters. No, I don't think that the idea of removal and then accepting, we didn't have House Bill 4 at that time. I think that those agreements will be revisited, but I don't have any doubt that Governor Abbott will be able to work that out with those folks. But thank you.